Welcome to our channel. Today, we're breaking down an important Supreme Court case that sheds light on how recovery certificates issued by DRT can impact insolvency proceedings. Stick around. Issues before the court. The focal issue being that whether the issuance of recovery certificates would give rise to the fresh cause of action to the financial creditor for the initiation of the CIRP. Another central issue is that does Clause 7 of Section 5 of the IBC includes a person holding a recovery certificate? Whether the liability of the claim arising out of the recovery certificate will form part of the financial debt as defined in the Code. Facts of the case: in 1993, Ind Bank Housing Limited, IBHL, sanctioned 3 separate credit facilities to 3 borrower entities. M/S Prasad Properties and Investments Private Limited became the corporate guarantor to the borrowing entities. The credit facilities were declared as non-performing assets by the IBHL following the default in the repayment of the dues. IBHL filed separate civil suits in the High Court of Madras against the borrowing entities and the corporate guarantor. Kotak Mahindra Bank Ltd, KMBL, the appellant, and IBHL entered into a deed of assignment during the pendency of the lawsuits, whereby IBHL assigned to KMBL all of its rights, title, interest, estate, claim, and demand with respect to the debts owed by the borrower entities. Pursuant to the above-mentioned deed, there was a compromise between KMBL and the borrower entities which was hereby recorded by the High Court of Madras. On account of continuing default by the corporate debtor, KMBL issued a demand notice followed by possession notice to the corporate debtor and the borrowing entities under Section 13(2) and Section 13(4) of the CIRP Act. A winding-up notice was also issued by KMBL to the corporate debtor as per Sections 433 and 434 of the Companies Act, 1956. KMBL filed 3 applications under Section 31(a) of the Recovery of Debts and Bankruptcy Act, 1993, RDB, on account of continuous failure for the payment of dues, which was allowed by the Debt Recovery Tribunal, DRT, and separate recovery certificates were thereby issued against all the respondents. Post the issuance of the recovery certificates, the appellant filed an application under Section 7 of the IBC before the NCLT, Chennai for initiating the Corporate Insolvency Resolution Process, CIRP, against the corporate debtor. The NCLT admitted the said application for the CIRP, and the corporate debtor preferred an appeal before NCLAT, contending that the limitation period of filing such application has expired. The NCLAT acceded the contention of the corporate debtor by allowing the appeal, and subsequently, the appellant, KMBL, approached the Honorable Supreme Court challenging such order of the learned NCLAT. Issues before the court: arguments by the appellant. The counsel for the appellant relied on the case of Dina Bank, now Bank of Baroda, v. C. Shivakumar Reddy and another, 2021, IBHL that IN 69 SC, in which it was held by the Honorable Supreme Court that a fresh right would accrue to the creditor and he would be entitled to recover the decretal dues as per amount specified in the recovery certificate when a claim is fructified into a final judgment or decree and the creditor is issued a recovery certificate. Therefore, the application should be admitted as it was initiated within the limitation period, i.e., 3 years from the date on which the recovery certificate was issued. Arguments by the respondent. The counsel submitted that the judgment of the Honorable Court in the case of Dina Bank is per incurriam and that it was rendered without considering the correct perspective of the relevant provisions of the Debt Recovery Act and IBC. Judgment. Thus, after analyzing the above judgments, the Honorable Court was of the view that the 2-judge bench in the Dina case was correct in law and hence the claim of the learned counsel stands unsustainable. The appeal was allowed and the judgment and order of the learned NCLAT was quashed and set aside. With regard to whether the claim emanating from the recovery certificate would be classified as a financial debt, the Honorable Court held that on perusal to the definition of financial debt, the words, means a debt along with interest, if any, which is disbursed against the consideration for the time value of money, are followed by the words, and includes. Pursuant to the purpose and object of IBC, it is clear that the legislature did not intend to maintain the debt fructified to a decree outside the scope of the definition of financial debt. Therefore, the claim emanating from the recovery certificate would be classified as a financial debt. With regard to whether the financial creditor includes the holder of recovery certificate, since it has been established that the debt on account of which the recovery certificate has been issued is a financial debt, thus, on drawing a natural corollary, it is settled that the holder of such recovery certificate would be a financial creditor within the meaning of Section 5(7) of the IBC. Hope you found this explanation helpful. Don't forget to like, share, and subscribe for more insights into important legal cases. Thanks for watching.